Welcome everyone. Thank you very, very much for coming this evening to our regional presentation and training on doing due process right. My name is Sam Light and I'm General Counsel for CIRSA, the Colorado Intergovernmental Risk Sharing Agency. I want to thank you. Alex from our Membership Services Department is recording the presentation, but I was joking with a couple of you beforehand that actually I want to take a picture of all of us together because you're the inaugural class for our new training facility. So we're very proud of that. You know, we got the training facility done just about the time something happened. I can't remember exactly. Well, oh wait, it was something happened, and so we didn't have the ability to meet. But now that we're hopefully emerging from the pandemic, we have more opportunities to use this facility, and I hope the space and the layout is to your liking, and so on. So also with us is Courtney Fagan from our Membership Services Department. If you have any questions about anything involving CIRSA, Courtney knows it all and is a great membership contact for all of you. So in terms of my presentation, as was mentioned, you know, we have this unique power in local government, which is a cherished power, right? And that's the power to make certain decisions at a local level that affect people's property rights. And those property rights can take many different forms. Tonight, I'm going to talk mostly about the quasi-judicial role surrounding decisions by bodies like planning commissions, city council, town boards around people's property rights for development or licensing. But it touches other areas as well, particularly for public employees who have, in many situations, protected property rights surrounding their employment. But at a local level, we have this cherished power to make land use, licensing, and other decisions that affect individuals' constitutionally protected property rights. And we want that power, right? We want within our communities to decide, right, whether this development's okay, or whether this particular license is something that's appropriate for this city or town. We don't want another entity, the state, or a federal judge, or a district judge telling us what's appropriate for our communities. But the grand bargain in all of that is that as the local decision makers, we have an obligation to make sure we honor people's due process rights, right, under the 5th and 14th Amendment to the U.S. Constitution. And that's what we're going to talk about. We know that in exercising that power, that can be a significant source of potential disputes and claims and, lo and behold, litigation, right? And part of what we do is our, bread and butter work at CIRSA on behalf of our members is we help them deal with constitutional claims, and we get our fair share of claims surrounding the exercise of quasi-judicial authority and due process claims. So we're going to focus on that. This is one of the types of trainings that we do when we go out and visit other members, just so you all know, and you can share this with your home entities. We do this kind of training for your city councils and planning commissions and town boards. We're happy to come out and do that combined with other liability training for you all. But tonight we're going to focus on essentially best practices suggestions for you all as quasi-judicial decision makers and staff supporting the quasi-judicial decision makers, suggested best practices on how to approach the due process hearings and the quasi-judicial role in a way that's going to build trust in local government, right, and at the same time help reduce your risk of liability. Though I'm General Counsel for CIRSA and an attorney, let's just remember this is not an attorney-client discussion. Okay, I'm happy to, and by the way, encourage questions throughout the presentation on any subject that you have. But recognize also that while this is not an attorney-client session, I also have a pretty good radar for what I call the live question of the day, right? So if your question is about the controversial development that's on tomorrow night's agenda, right? And you go, well, I need some help understanding what we can do as a board or a council. That's a question for your support staff and your city attorney. So make sure you touch base with them. I'm happy to give you my suggestions, but for those live questions, you want to check in with your staff and your legal team. Okay? Let's talk about the larger context, particularly for the council members and planning commissioners. Local government's such an interesting thing because we do a lot of different things every day. right? And at the decision-making level, sometimes we're making like routine business or administrative decisions. In my world, they call those administrative decisions. Sometimes we're more like legislators, and we're making policy, broad policy, that doesn't apply to anybody in particular, just applies to everybody in the abstract, and we're just putting down general rules. Maybe they're like nuisance laws or animal control laws, or in this world of development and licensing, maybe we're just making new laws about the general development criteria or the general criteria for getting a liquor license or a marijuana license. When we do that, we're acting more like legislators, right? So now we got this fun job of being an administrator sometimes and sometimes being a legislator. But tonight we're going to talk about that third point on the hat, where we're acting like judges, right? Sometimes you act like judges where you make specific decisions that affect people's individual property rights. We call those quasi-judicial decisions, right? At the local government level in Colorado, that primarily means for bodies like city councils and planning commissions, it primarily centers around land development applications and licensing applications. Other boards and commissions that get into this activity include probably the Board of Adjustment, right, because they handle variances, which are quasi-judicial matters. Historic preservation commissions, because they make decisions like alteration certificates and so on and so forth. And who else? The folks who are not elected officials, are you supervisors sometimes? Yeah, right? So if you look at your personnel handbook, quite often it's going to say something like, before we impose significant disciplinary action or before we fire you, you're going to get a hearing. What have we done? We've now essentially promised that person due process, right? So we have an obligation there as well, right? So in all those areas, we as municipal officials are required by law to provide due process, and a failure to provide the appropriate level of due process can create liability risks. Here are some examples to show you the contrasting roles. On the left-hand side, I've just shown you a couple of examples of what are legislative actions, right? So your city or town's approval of a master plan or the adoption of a tax or a decision to annex property or just making general code revisions, that's all legislative. You're not wearing your judge hat. But on the other hand, when you're making these individual determinations like a rezoning for a specific piece of property or deciding whether to approve or deny a liquor license or a marijuana license, or suspend or revoke an existing license, right? Now you're in that quasi-judicial mode. Same thing for certain types of subdivision and development applications and in the employment context as well. My little footnote that may be difficult to read from out there is my disclaimer. What constitutes a quasi-judicial determination for which you're going to have to follow the due process rules of engagement, right, is going to vary a bit, right? There are certain big baskets that in every case are always going to be due process hearings, like a rezoning. But in the employment context, you're going to need to look at your personnel manual and see what it says, right? In the land use context for some types of applications, your code may say that that is administrative and is not quasi-judicial. So it depends in part on your entity's own specific ordinances. I'm sure your city or town attorney's office helps you identify what those are, and they become pretty apparent pretty quick, because what happens? Right? From your perspective, the agenda says public hearing, right? And from a supervisor or administrative standpoint, it's, oh, the manual says this employee is entitled to a hearing, right? So we know it when we see it, okay? The due process rules of engagement, the quasi-judicial decision-making rules of engagement have a very familiar source that no matter, I found over my years of doing this, that everyone can agree upon their commitment to the source of where this comes from, right? We have a lot of disputes and controversies around how you actually get there, but everybody understands that principle of no person shall be deprived of property without due process of law. And that's the underpinning, right? Under all the millions of pages that have been written about due process, and then the hundreds of thousands of court decisions, all stem from that very simple concept in the Constitution that no person shall be deprived of property without due process of law. We want the power to make property rights decisions, right? But in our city or town, if you're on the planning commission or town board, remember that at the end of the day, if you're a 7-member council, only 7 council members, right, get to make that decision, and the grand bargain is with that power goes the obligation to make sure that you provide people their due process. All right, what are the key characteristics of a quasi-judicial process? We kind of know instinctively what those are, right? And you follow that every time you go through one of these proceedings, right? But the core components of a due process or quasi-judicial hearing is we're going to give notice, right? Usually we're giving extra notice, like individualized notice to the applicant or the employee, right? For land use matters, we're going to give extra notice to the surrounding neighbors. If it's licensing, we might even post the property, right? That's the mysterious underpinning of that 4-foot-tall poster for liquor licensing. And, you go out on Saturday night, that's curious. Who filled out that poster? That's all part of the due process obligation to give notice, right? Hey, this premises is subject to a new liquor license. So we give extra notice, and we're going to have a hearing in front of a quasi-judicial body, right? And that kind of hearing is essentially an evidentiary hearing, just like a trial. It's like a mini trial. We're just not wearing the robes, right? But it is quasi-judicial. We can almost drop the word quasi, because what we're asking local officials to do is act just like judges. And at that hearing, everybody gets to come in, present all their information, all at the same time. Everybody gets to hear each other and hear everybody else's testimony and review everybody else's evidence. What does that sound like? Kind of like a trial, right? And the last rail of that, the fourth component, is that the decision, right, is going to be made by people who are assigned with the obligation to be a fair and impartial decision maker. That's you. That's you. And that's it. Those are the 4 basic pieces, right? Recognize, though, couple of you mentioned you were on the Planning Commission, so for some matters you probably make a recommendation to your colleague here on the City Council. You don't make the final decision, right? But recognize that the requirement to commit ourselves to due process attaches very early in the process and attaches throughout the process. So even if our body is making a recommendation to another body, that lower tribunal is still required to provide due process. So the Planning Commission follows the same due process rules when it holds its hearing. Every step in the process is a critical building block to ensuring that we give people their fair procedures. Yeah.
What I found surprising about that is our decision has to be based only on what we hear at that hearing. We can't talk to anybody outside of that.
Yes.
That was news to me.
Yes, and we're going to break that down, what that means and why that's so. And as we prepare to hold that thought and think, as we prepare to talk about that, think in terms of this. When you have a court proceeding in front of a judge, does the judge chat about the case with the parties or other people outside of chambers or outside of the courtroom? Yeah, so think about how it translates to, seems less formal, but the same legal principle applies. So we're going to talk about that in a little bit. Let me give you some legal context. How many people here like process?
Like process?
Like process. Even higher, how many people love process? Right? That's what we do in local government. One of the products that we provide, one of the most important products that we provide in local government is to provide a forum and a place for people to discuss important community issues, and then ultimately for the people who hold the power to make those decisions to exercise that power. You have to like process in local government, right? Our Court of Appeals has said that quasi-judicial proceedings must be conducted in accordance with procedural due process. What's that all about? Fundamental fairness of process. Process in and of itself is a product, right? And a fair hearing is critical, right, to reaching a good decision and ultimately defending it. In fact, this is how important process is. Process in this area is, from a legal risk standpoint, process is probably more important than substance, right? Because generally, if your decision is legally challenged, right, and it goes up to a court, the court's going to look at that, right? But the rules generally are in your favor with regard to substance. On the substance of the issue that you decide, as long as your decision wasn't completely arbitrary and capricious, right? The judge is essentially duty-bound to uphold your decision, right? The other thing going on is when you hold that local hearing, that's the one and only hearing, right? That's why process is so critical, making sure that everyone has an opportunity to be heard, making sure that everyone has the opportunity to put in their evidence, to ask questions about other people's evidence. If your decision is legally challenged, the district court judges don't retry the case. We don't get a do-over in front of them. What the reviewing court looks at is a transcript of your hearing, and that's the place to make or break a defensible decision, right? Because that judge is going to look at the procedures that you used wearing their judge hat. Did they give fair process? Did they follow their own procedures, right? The judge is going to look at the evidence that you considered. Did they consider the relevant evidence given the criteria that are in place within that city or town? And then the judge is going to look at the reasons for your decision, okay? And again, the judge doesn't usually overturn your decision because they didn't like it. And we don't want that anyway, right? We don't want a district court judge saying, I wouldn't have voted it, in favor of that development. I reversed the decision because I think the building's too tall. No. That's your decision, right? More likely, the judge is going to look at the ultimate on the substance. They're going to make sure that you were within this box where you have pretty wide latitude. Just make sure that you're reviewing competent evidence and that the decision you reached is based on some competent evidence in the record and is not a wholly made-up arbitrary decision. If you do that, you're going to be fine. But the other thing the judge is going to look at is what were the procedures, and did the city or town, the city council or town board, either as a group or because of some individual behavior, deprive one or more of the participants of fair process. These are judges reviewing the conduct of quasi-judges. So what's the lens that they're going to use to look at how we conduct ourselves as quasi-judges? Probably the same lens that they would look at how they, right, are required to behave in making sure that people's due process are honored through judicial proceedings, right? So make sure you keep that judge frame in mind, right, when you're conducting your due process hearings, right? And individually and as a group, make sure that we honor, right, the things that judges would do and stay away from the things that judges wouldn't do, okay? At the end of the day, process, the way our U.S. Supreme Court put it, it's a flexible concept, but what do we think due process at its core really means? Fairness. And an opportunity to be heard, right, in a meaningful way at a meaningful time. And that's really just the spirit and the attitude that we embrace when we hold these hearings. Let me give you some practical tips for ensuring fair process. These are all pretty common sense, and there's some more listed on the other handout that I provided with you, but a couple of tips. Don't make up your mind before the hearing. Why not? What do judges do? They make up their mind after they hear the evidence, right? Don't make any prejudicial pre-hearing statements, right? We want you to be able to exercise that power, right? I don't want you to face a objection at the beginning of the proceeding, right, from one of the interested parties saying, oh, I'd like that commissioner or council member to be disqualified from participating because they made pre-hearing prejudicial statements, right? You may, as a policy or legislative matter, I'll borrow marijuana as an example, you may be opposed to that. You may have thought it was a bad idea for the state to get into that. You may have opposed the proposal when your city or town decided that they were going to allow and license and regulate marijuana establishments. But now, if you're on the board that makes licensing decisions involving marijuana establishments, you don't want to be the one the week before the big controversial hearing saying, I will never vote in favor of another marijuana establishment again. Why? It evidences prejudgment or bias. And is that contrary to the applicant's expectation of due process? Absolutely, right? So don't make any prejudicial pre-hearing statements. Don't speak with one side or the other outside of the hearing. That's called fancy word that I paid a lot of law school tuition for, ex parte communications. We'll talk more about what that means in a minute. Obviously, if you have a conflict of interest under whatever your local code says about these issues, then you want to recuse yourself and not be a participant in the hearing. If you have questions about that, we can chat about that, but I just wanted to make sure we knew that. Don't sign any pro or con petitions. This comes up in liquor licensing sometimes, right? I never understood this mystery, but you know, the person who wants the liquor license always shows up with a nice big petition that says everybody wants, we need another retail store. And it's, well, first of all, they're not even legally required. What the statute actually says is those petitions are one way, but not the only way, to prove the needs and desires of the neighborhood for another liquor license establishment. But I've seen a lot of time and energy spent on like looking at signatures and chatting about that. If you're on that board or commission, you don't want your name on that petition. That looks odd, right? So stay away from signing pro or con petitions. Don't become an advocate because we are a judge, right? Don't become a witness in your own hearing. This is a little bit tricky sometimes because I'll give you an example. I had a development application where the whole controversy, as was allowed, was focused on traffic, because one of the decision-making criteria was that the development shall not unduly impact traffic patterns or cause level of service within the surrounding streets to be degraded, right? The applicant could fix that by investing in more street improvements. But so it's a very controversial development. Everyone was focusing on that. And I had a planning commissioner who said, well, you know, applicant, I've heard your traffic analysis. And staff, I've heard your traffic analysis. And I don't like either of them. So over the weekend, I went out and did my own traffic counts. Good idea? Bad idea. What if after saying that, that planning commissioner says, and so that's my view of the traffic counts, and I think it's going to impact, based on the study that I did over the weekend, my traffic counts, I'm going to go ahead and vote to deny this application because of the great testimony of me. Does that sound weird from a due process standpoint? Yeah. Yeah. So, but here's the flip side of that. Recognize that one of your greatest strengths, and I think it's your prerogative, is if that situation rises up in your hearing and you're skeptical of the traffic report or skeptical of, yeah, you have the power and prerogative to ask questions and to ask for more information, to the point that others might get frustrated and think, well, why doesn't the commission just move it along, right? Hey, I have a right as a quasi-judicial decision maker to take the time that I need and get the information that I need to feel comfortable that I'm reviewing this, right, with the information that I need in order to apply the criteria to this decision. So in that situation, instead of becoming a witness, you can flip the narrative on that, and instead of testifying with your own knowledge of why you would vote yes or no, you just ask others to give you the information you need. So it's just, yes, sir.
Question along those lines. If you're in a hearing and you are going to recuse yourself,
yes.
Okay, I know this guy, so that's not, fair. Can you still participate in the discovery of information?
The discovery.
I'm sitting in a planning commission. Can I ask him questions and bring out points that may not be brought out by others, even though I'm going to recuse myself when I vote?
Yeah, there may be one bit that's not filled in there. Does that, you mean in terms of then presenting evidence to the commission?
No, just asking questions.
Oh, so you're going to have a local rule from that, but I think in general, most codes of ethics will say something like, if you have a conflict of interest and you've decided that triggers an obligation to disclose and recuse myself, that most codes of ethics will say the obligation is to recuse yourself from the discussion and vote. And yeah, but you need to check your local and your home rule as well, right? So you'll want to check your code of ethics in your own community on that. Yeah, but most of them will say recuse yourself from the discussion and vote. Yeah.
It doesn't come up often, but once in a great while.
Yeah.
When you've been in the business before.
Right. Yep. Yeah. Yeah, I think you'll probably have an obligation to recuse from the discussion and vote. If you're a statutory municipality and you're subject to the state code of ethics, it's going to say, and you have you admittedly have a conflict of interest, it's going to say disclose, recuse from the discussion and vote, and don't attempt to influence the other decision makers as well. So that's I must completely step away. Yeah. Yes, sir.
What about situations where you're assessing the credibility of two people that are making claims that are in conflict with each other? You don't necessarily have time or resources to, get further information.
Right. But you have that right. Every quasi-judicial decision maker has the right to assess and weight the credibility of the witnesses and testimony that's provided. What I suggest to you is articulate that during your deliberations. I find the applicant's traffic study.
No traffic on C-470 to not.
Right, because I see the conflict between the various studies, and based on my review of that information, I believe this is more credible because whatever it is.
But
They did more.
This could be my own personal experience. It is not too different than that person going out and doing his own experiment and observing.
It may not be your own personal experience. You may find one more credible than the other because of the details within the information that you've received. On traffic, for example, I've seen this dispute bubble up a couple of times where the quasi-judicial decision makers say, I lean more towards this analysis of traffic because that analysis of traffic was done between midnight and 4 a.m. And that this is the one that gets to the traffic counts during rush hour, that kind of thing. It's not usually not that black and white, but nuances like that, right? So, that helpful? Yeah. Okay. Any other questions around those issues before we go on? The other suggestion is, so being a judge is a little bit of a lonely job, right? So make sure that you discuss and consider quasi-judicial matters only at the duly noticed public hearing for the body of which you are a member. And the reason I say it's a lonely job is it requires you as the decision maker, the one holding the power, to make the decision, to wait until the matter has arrived on your agenda and is ripe for you to hear, deliberate, and decide. Right? Due process requires that we not engage earlier. A little bit lonely because I get it, your citizens, constituents, the whole world knows that next week is an incredibly controversial development application. And the natural inclination as a citizen is I want to talk to my elected official about how they're going to vote. Or I want to talk to the planning commissioner about how they are going to vote on that, right? So we'll talk a little bit more about strategies for ex parte communications in a minute. But as it applies to this portion of the presentation, respect the allocation of responsibility. Recognize that as the final decision makers, you just want to wait till it's ripe and comes to you. And that probably even has an internal dynamic as well. If you're one of those communities that has an allocation between the governing body and the planning commission, then remember that we as an organization created that structure for the specific purpose with the specific intent to give that lower tribunal, right, the freedom to do its job. I know there's some debate about, hey, if I'm an elected official and I'm on the governing body, can I go to the planning commission meeting? Okay. People ask me what's my suggestion. My suggestion on that is don't do it. Right? Why? Because you ultimately have your own hearing and you get to decide the matter, and you already have an organizational structure that says planning commission does its job, then they provide you with a recommendation, and then you take over from there. And you can see that's kind of an organizational allocation of responsibility. Yes?
Can you read the planning commission's material is always included with our item on the agenda. Can we read through that information? Yeah,
for your organization, you want to check locally on your rules and with your attorney on what the specific things are. But in general, if your system says that certain components of the Planning Commission's evidence are part of the council hearing, then that's fine to consider that. And I've worked around those issues quite a bit. Some communities will say that the minutes of the Planning Commission meeting are part of the hearing record. Some will say, have a system where the Planning Commission actually provides a resolution with a recommendation or provides a written memo with a recommendation. Whatever that looks like, you just want to sort out within your own organization what parts of the hearing record from the lower tribunal, right, are appropriate for consideration by the council in your case. Right?
That brings up a really good...
I had a follow-up.
Okay.
But go ahead, if that brings up something direct for you.
So what about the reverse? Can a planning commission person go to the city council meeting that's in public and either explain their decision or explain as a person in the public what their opinion is about that.
Yeah, check with your city attorney for their advice on that. I have a couple of concerns around that. First, if you're going as a representative of the Planning Commission, is that understood that that's the process? Is there agreement organizationally that that's how it's done? Because if you have to admit that if you're going as a representative, then you're representing a body. So does the body agree that that's the method by which it will do this? And then if you're going as an individual, you have to recognize, in my other trainings, I always say, if you're an elected or appointed official, in many respects, it's a 24/7 job. Please don't give up your personal life, but you always have that hat on in the eyes of your constituents, and particularly on due process matters, right? You have to remember you're still one of the decision makers in that lower tribunal, so I think it's difficult to take the hat off and say, I'm setting that aside, I'm not speaking about the decision or recommendation I just made, right? So here's my piece. Now, what if that mattered? Here's the risk factor, one of the risk factors among others, is what if you said something there as a private citizen, but it was different than what you said as a commissioner on the record wearing your commissioner hat, and then that same application ended back up in front of the commission? Can get a little sticky, right? So that's why I say you have to have an agreed upon organizational method by how the recommendation moves up from the Planning Commission to the town board or city council.
And the risk of following all those rules, in my opinion, is that sometimes the council members don't understand our reasoning process.
Right.
And you know, nobody's going to spend 3 hours writing a dissertation to help the council members understand.
Right. Sometimes I see, and this doesn't create a due process concern, it unfolds this way, where the member of the governing body asks the planning staff, explain more to me about the Planning Commission recommendation. Why doesn't it create a due process concern? Because that's all unfolding at the hearing on the record, and that's just fine. And then someone, it rarely unfolds this black and white, but what if someone jumps up and says, well, I heard your planning director say that that's what happened to the Planning Commission, but that's not really what happened. Let me tell you what happened. Okay, now we're going back, conflicting testimony, and you have the power as the decision makers to weigh all that evidence and make credibility determinations, so on and so forth. So, okay.
Was that where you
No. The other one about influence is social media. And while you are not talking directly to either the Planning Commission or attending a meeting or talking to the developer or talking to anyone else, it's on social media, and residents or even sometimes the developer is trying to work the system as well by social media, whether Facebook or Nextdoor or something like that.
The concern for the decision maker is that you're receiving information outside the hearing. If you're a juror in a trial, what do they tell you the first day of the trial? Don't read the paper. Yeah. So it's analogous to that. My larger perspective on social media is, remember, we're the ones with the power to make due process decisions. We have good systems in place to assure due process. We should be champions of that process. Social media is not a good place to adjudicate a controversial quasi-judicial decision. It's going to happen. That noise is going to be out there, right? But when you see it and you're one of those decision makers, then you just discontinue reading it. Someone comes up to you and says, did you see all that traffic on social media about the hearing next week? No, I didn't, but I look forward to hearing all about that project at our hearing next week. That kind of thing.
Thank you.
Yes. So that's just, and to wrap that up, it goes to this bullet here is, there's a lot going on before it gets to you, right? But don't engage in that buzz that's going on before it's ripe and in front of you as the decision maker.
Engage with other judges that sit on the committee, right? The 7 members of the board aren't even allowed to talk to each other.
Right.
And some of these things get complicated where there's a lot of information.
Right.
And you have to gather it all in that meeting. And it's challenging. So.
Yeah, and sometimes in the bracket on the side of the agenda it says this matter is scheduled for 30 minutes.
Yeah, you're kidding.
All right, you have the power and the prerogative, though it may must frustrate any number of constituents or staff, you have the power and prerogative to take the time you need, right, and get the information that you need. So if the group, Again, of course, it's the majority determinations on these issues, right? If I'm the one member that says I'm not ready, but the other 6 tell me, well, I think I'm ready to vote, well, it's probably going to get voted on that evening. But I think in terms of at least getting the issue on the table, if persons feel like I have more questions, at least square the question for the group. Hey, do we need to continue this hearing? Margie.
Sam, at what point in the process does it become quasi-judicial? I know we had that issue in Lakewood all the time. Is
Yeah.
When they receive the application, or, I mean, is there a certain point where the city accepts the application, or maybe some advice on
Yeah.
how do we create that policy for a city?
Right.
This is where it comes, this is the point.
Right. If okay with you, can we hold that till we get to ex parte? Because it primarily relates to when does the rule kick in that I cannot talk to other folks. Well, we'll get to that in just one moment. The flip side of the don't engage in pre-hearing buzz is at the tail end of the process, recognize that once your body has made its recommendation or decision, let that decision speak for itself, right? And even if you held a minority view, it was a 4-3 vote, I think everyone kind of has a fiduciary obligation to at least respect the decision that was reached by the body itself. I'm going to give you a scenario as to how that can translate to risk. I'll leave the second one in the interest of time. I'll just leave the one at the top of the slide there, but let's go through the bottom one. So in this scenario, we recently approved a controversial development and resolved the fire district's concern with a condition of approval. That's pretty common, right? Had a condition of approval that requires the developer to obtain a fire access over the neighbor's land. The neighbor even came to the hearing and said that he's willing to grant that access. One member who voted against the project, it was a 4-3 vote, after the hearing approached the neighbor and asked that he not grant the easement. Are there concerns there? What do you think?
It's pretty obvious.
Yeah, pretty obvious, right? Is there a due process concern? There might, this commissioner, let's say it's a planning commissioner, this person may say, well, hey, our hearing was over. There's no due process risk because our commission's never going to hear that again. But what if that developer isn't able to get that access? Maybe he's got to come back and amend his application, and who's that going to land in front of, right?
A 6-member council.
Yeah, 6-member, right. So, this is a matter of sort of politics, I suppose. The people who are in the 3 side, they can remind their constituents, hey, I voted against that project, but I think they have an obligation to say, but the decision of the group was to approve. There's actually an even more significant risk here for that member individually, and that's a tort risk, right? Because didn't the commission say, essentially, you have our okay as long as you get that easement? We may have created some type of protected expectation for purposes of tort liability, right, where that developer says, all I got to do is get the access and I'm good. But wait a second, one of the people who had a voice in the decision, right, is now out there attempting to affirmatively undermine my expectation of some business advantage that I may have in the future. And that's actually a tort in Colorado. One can be held liable for tortious interference with prospective business advantage. And that's the concern that I have for that particular member. Okay, let's talk a little bit about running good hearings. Yes?
Sorry, I wanted to go back.
Oh,
to
sure.
that one that you skipped over.
Yeah.
It
On that
reminds
top?
me, since there are campaigns going on right now, that people make statements all the time.
Yeah.
What they're for and what they're against.
Yeah.
What is the impact of that as you do quasi-judicial hearings in the future?
Yeah, so if it comes, the way it would come up is that someone shows up at a later hearing and says, I would like to ask that the body disqualify council member or commissioner this because of comments that they made during the campaign. Their burden of proof is fairly high. They have to show prejudice, right, to them, and they also have to show essentially that your mind was irrevocably closed. Does that solve all your problems? It takes care of the legal risk probably, right? So my suggestion is be cautious and careful. I want you to be able to exercise that power, right? The burden on the person who would seek to disqualify you is they basically have to show you that through your statements, you have evidence that your mind is closed. So, you say once or twice what I said earlier, right? I will never vote for another one of these again. That's pretty good evidence against you, right? But if it was a more qualified statement that said, my personal view is I'm generally opposed to marijuana establishments, but I understand if elected that I will give everyone a fair shake when applications come in front of me, then you're protected, right? So that's kind of the rules around that issue. Yeah. By the way, not yet settled by our appellate courts, and I don't know if it will be because this proceedings on these cases are very mysterious, but those of you who are elected officials know that at some point in time, we might get a decision out of our appellate courts as to whether campaign contributions in and of themselves to elected officials create some basis for claiming prejudgment bias. In my world, municipal attorneys, I think, always felt that that was not the case. And I don't know if the decision's going to ever come down and change that, but there is a pending case where that was one of the issues raised. It's out in northern Colorado. Okay. All right, on the hearing side, whatever it looks like to your organization, quasi-judicial proceedings, due process hearings from employment matters, this isn't the place to wing it. Have a script, follow a standard set of procedures each time, make sure the audience is habituated to what our procedures are. And one of the things that happens if you're a presiding officer or a person who's sitting over the employment hearing, right up front tell everybody what the ground rules are. Okay? You don't want to allow people to conscript your power by saying, oh, and by the way, applicant or employee, are you okay with these ground rules? What if they say no? Right? If I know the ground rules are fair and defensible and give them more than their adequate share of due process, just announce what they are, at least. In land use hearings and licensing hearings, things can get a little emotional sometimes. Is that right? That's what I hear. I haven't seen. I think you can expect civility, right, and have techniques for that. If things get emotional and looks like the room's about to boil over, I think one of the best tactics is just to take a recess, right, and see if we can get cooler heads to prevail. The chair does have a power and prerogative to maintain order. You probably have within your jurisdiction little rules on how long people can speak and so on and so forth. Just make sure we're consistent in what we do in that regard. I think the trouble starts to brew when there's a sense that they're not being applied. Those kind of procedural concepts are not being applied even-handedly. Okay. Oops, excuse me, I went the wrong way. When you're in your hearing, stay focused on the issues at hand. The time to start getting ready for a quasi-judicial hearing is way before the hearing. It's when you get your packet and you start preparing, right, reading that packet and thinking, I'm now going to start jotting down the issues that are important to me and the questions that I'm going to have when we get to that hearing. On employment matters, maybe you've got an investigative report that's got a couple of open-ended, a couple of loose ends, right? These are the questions that I'm going to have for the supervisor or for the employee or for the command staff when I adjudicate this. So you want to be ready in that regard. The other thing, in addition to things getting a little emotional, sometimes these hearings sort of have a ship's passing feel to them, particularly like sometimes development plans, right? You got a new proposal for an apartment complex. The zoning allows it, and we're at the final development plan where we're really just looking at architecture and building height and landscaping. But half the public testimony is, you should vote no, this property should have never been zoned for apartments to begin with. That's my ship's passing, right? Because you're all focused on the criteria for this little final development plan application. And everybody over here is thinking, you never should have got here in the first place. In those kind of situations, we want to recalibrate the discussion. It can be a little uncomfortable sometimes, but we have to remind folks, and by our own behaviors, right, show that this is what this hearing's about. We're at this stage in our process, and this is what I, as a decision maker, am duty-bound to focus on this evening. So thank you for the comment that it never should have been zoned or annexed in the first place, but that's not where we're at. Our obligation tonight is to focus on this particular aspect. Okay?
That brings up a really important point in that In our case, I think we need to do a better job of the comprehensive plan, because the comprehensive plan sometimes can be expanded to include things that really aren't intended at the time. But now all of a sudden, an example that we looked at a while back is we would allow a gas station, but the intent wasn't a truck stop.
Right.
And we got into that discussion of how you define that.
Right.
And so on.
Yeah, and those can create risk if we're defining that on the fly. Right. And that leads to this point about the mixing and matching of quasi-judicial and legislative roles. Right. We know that sometimes a hearing doesn't really work out the way we thought. We look back and go, oh, those development criteria didn't really, or the table of uses in this particular situation didn't really get us the product that we wanted as a community. I think part of the obligation is we just have to admit that, well, that's the way it worked out, but we can change the rules for the next one, right? But getting creative about our interpretation in a way that's not going to be defensible, that's what can get us into trouble. All right, let's talk about ex parte contacts. Margie, to get to your question, an ex parte contact is a rule that basically says that when we're in a quasi-judicial proceeding, the decision maker shall not have any contacts with interested parties outside of the hearing. When is that rule triggered? I have seen some communities that adopt a written rule that says the day the application is submitted, that's when when that rule is triggered. And that's a helpful kind of bright line rule, but is it really all encompassing? Probably not. Right, because we know that what if a developer, just to take it head on, what if a developer comes to you and says, tomorrow I'm going to submit my rezoning application, but I haven't done so yet, so today can I talk to you at length about why you should vote in favor of my rezoning application? You can see that bright line rule was helpful in some regard, but didn't solve that situation, right? So from where you sit as a decision maker in these issues, you need to have your radar up and know that if someone wants to talk to you, right, about the merits or substance of something that's going to end up in front of you as a quasi-judicial matter, you always need to be vigilant and say, hey, I can't really talk to you about that level of detail. I get it that you're a property owner in the town. I get that you're interested in rezoning your property, but I'm not going to play my card here now and engage in that discussion with you. You just have to go through our process, and I'd look forward, right, to hearing about your application if and when you file the application. Okay? Yes?
We occasionally have proactive sort of people that are thinking about setting up a daycare center or probably a whiskey distillery, and they just want to chat with the board about, is this going to fly or not? Are we breaking rules here? I mean, it's at an open meeting. It's sort of in public comment phase of a town board of trustees meeting.
Yeah.
And often the application never gets submitted.
Right. Right. If you sense that they're really an applicant in waiting, then you have a great support system to help you with that, right? You can unburden yourself by that by saying, well, we've got a lot going on in the community and we've done a lot to articulate what our vision is and what we want as a community. So I would encourage you to get together with our planning department or our town or city manager's office, whatever it looks like within your community, and they can help you with the resources to understand what zoning you have, right, what the process is to make this request, right, that kind of thing. On the liability side, I'm not too worried about them, during this casual conversation. We say, oh, we'd like to bring a food truck park to the city. What do you think of that? And you go, oh, great idea. But then they get into the process and it's turned down. They're not going to have a promissory type claim in that. But again, we want to be champions of the process we have, right? So that kind of thing, if for political reasons it's a feel-good comment to say, that sounds like a great, interesting idea. Generally, I think that's an innovative use of land. But within our particular system, right, if that's what you're proposing and you want to know how to get that done in the city, then please go talk to our staff and they'll help you get pointed in the right direction. That help? Somewhat.
I mean, we usually don't provide any feedback as board members.
Yeah.
But they present it and other members of the community are there and they have things to say about it and we just gathering.
Even better from a risk perspective, because there's a process for it to have that discussion. Okay, on ex parte communication, so the rule is that as the decision makers, you don't want to have communications with interested parties about the subject matter of the hearing outside of the hearing, and I've given you some examples here. I boil it down to, for all of my examples on the screen here, just think in terms of this. If this were your request, right, if you were that property owner or you were the person that wanted to open that restaurant that needed a liquor license, would it seem fair to you if you knew the decision makers were having these kinds of communications? Where does it all stem from? The due process clause. One of the analogies I use is it's almost as simple as this. If you and I were in a private lawsuit and I owed you money and you got tired of waiting around for me to pay and our trial's tomorrow, right, then your expectation under the due process clause is that I'm not on the phone with the judge the night before saying, Judge, how's it looking? You know, you're going to rule for me. We have a similar obligation at a local level when we are wearing our quasi-judicial hat. That's why we need to stay away from ex parte communications. The actual legal liability risk here is that if proceeding is loaded up with all sorts of evidence that the decision makers were talking with interested parties and communicating with them outside of the hearing, then that's evidence for a party who wants to attack your decision to say, right, that the decision makers actually weren't making the decision within a proper due process framework. They were being influenced and learning all sorts of things outside of a hearing where I could hear the evidence and test the evidence, okay? So what you need to do here is arm yourself, because I get it, you know, people are going to approach you and want to talk to you about it. Arm yourself, whatever it looks like to you, with some talking points. It's not that we don't want to hear from people, we absolutely do, but only within the proper process. So whatever your talking points look like, I've given you one here, and now you can tell your constituent, hey, I'm sorry I can't chat with you about the rezoning or the development request that's on the agenda next week. I can't do that now because I'm one of the people who has to make the decision. But if you can, come to the hearing, right? If you can't, you can submit written comments, that kind of thing. I find if you're support staff, one of the things you can do, because these rules stick to us, we're all the insiders to local government, we get it, right? The citizens don't, and we have to, it's kind of our responsibility to help educate them as to why there's that kind of arm's length thing going on. So support staff, maybe one of the things you can think about is within your website, you have something you can point citizens to, and then it's something for your elected and appointed officials to point citizens to. It says, oh, that's a quasi-judicial hearing, that's a rezoning hearing. We have certain rules that apply to that. If you click on our website, they explain what that is and how the process works, and then you drop in something about this rule. Yes?
So what if some of your community members and constituents didn't know that this hearing was coming up?
Yes.
Didn't know that it's really going to affect and impact them?
Yeah.
Is it inappropriate to inform them about it or invite them to the meeting because you know there's going to be on the agenda and you value their input and think the rest of the council members should hear it?
Yeah, if they ask, not a problem. If our notice is inadequate, maybe that's a problem. But how do we solve notice? We generally decide what's the notice rule that's going to apply universally. I think where you can get into a potential pickle, and it's actually mentioned in one of the chapters of the book here, is if I'm, even with the best of intentions, letting people know about a hearing, what's my motivation? Right? And would it unfold in terms of, oh, by coincidence, it just turns out that all the people that I reached out to let them know individually, they all ended up being on the pro side of the application, right? Or they all ended up being on the con side, right? May not ultimately result in a third-party liability risk, but it may be a risk that's above my pay grade, to be frank about it, right? If the accusation is, well, some of the members of the body, right, went above and beyond the notice that was given, and they went out and tried to procure individual people, right, who were going to support their bias towards approving or denying this application. Would that be a good look? No. Yeah, so I think the conversation around that from community interest, because we do want communities to know what's going on, is to make sure that as the quasi-judicial decision makers, you have a system for the level of notice that you want. Now, if the person approaches you and goes, what's this I hear about this marijuana stuff? You can check our website, check with staff. We're going to have a hearing on that. You can find all sorts of information of when the hearing will be. And we'd love to have you come to the hearing and participate. We love whenever people come to our hearings. So, Okay. There's on this slide, just in the interest of time to move along, I just point out here a contrast between the legislative role and the quasi-judicial role, right? When you're wearing that legislative hat, you can lobby and be lobbied outside of the meeting. You can base your decision based on your own personal policy perspective. You can consider any information you want. But when you're in a quasi-judicial role, completely different, right, for the reasons that I just went over. Okay, let's go over one of these scenarios. Let's do the bottom one. Let's say our board member, and here I'm talking about a town board, let's say one of our board members is unable to attend the upcoming board hearing on a rezoning request. So over the weekend, he emails another board member, tells her she should vote no because the request is inconsistent with the master plan. The other member, Tammy, responds to denial, copies in another board member, and says, yeah, traffic impacts are also a huge concern. Then that third member hits reply all, right, and says, hey, I went to the developer's neighborhood meeting and it didn't go well. Do we have due process concerns here? Boatloads, yeah, and you touched on this, right? It's individual quasi-judicial officials speaking with each other before and outside of the hearing. That's a concern. By the way, you also have an open meetings issue here too, don't you? You have 3 or more members discussing a matter of public business, right, without meeting the openness requirement of the state statute. So I know sometimes you get unsolicited emails about development applications. Anybody get those that are coming up? Yeah. So whatever your protocol looks like within your community, our suggested practice is if you get those, somebody sends you the email at home, right? Dear council member, here's all the reasons I think you should vote no on that development application. What do you want to do with that email now that you've seen it and started to read it?
Read it, but you should send back that little paragraph that explains what a quasi-judicial matter is.
Yeah, or have a stock answer that says I can't respond to your email. But if you've already read the email, what's happened already? You've now learned information that the other commissioners or council members may not have. So a lot of our members will have a protocol that says if you get information bearing on the substance of a quasi-judicial matter personally in your email, then forward that on to staff so that it can be made a part of the record, right? And that's how we cure that. Because just by making it a part of the record, then anybody who wants to read it can read it. Anyone who wants to challenge the information in it has the opportunity to do so at the hearing. Okay? All right, now, wrapping up procedurally now, we've had our great hearing and we're nearing the end of the hearing. And now, the applicant staff have presented, the citizens have all spoken. We're now bringing it back to council or the board for deliberations. This is your chance to shine. This is the best part of the process, right? This is where you and your colleagues are going to discuss the evidence, right? And what's going on there? A couple of different things, right? You as a body are formulating the basis of your impending decision. You're giving everybody in the room an indication of where you're going, right? You're starting to explain why you're going to decide this case the way you are. And what's happening more from a legal technical standpoint, we're making a record of why we're going to decide this case the way we decided, right? So deliberations are always a great thing. Your constituents love it when you talk with each other about how you're going to decide a case. So deliberate. Great place to be. Irrespective of legal risk, there's a little awkwardness from a constituent standpoint, right? If you get all these presentations and it's quasi-judicial, and the only thing that happens is hearing closed and somebody just says, I make a motion to approve. What's happened? From a risk standpoint, there might still be, within all that mix, enough competent evidence to defend your decision, right? But what do the people there want? They want to hear. They want to hear from you. Why did you vote the way you did, right? So embrace that part of the process, right? It's always your prerogative to ask a question during deliberations of staff. How does this criteria apply? Remind me again. What's the decision we have to make? What are the rules? How do we interpret that particular piece of our code, etc.? Okay? A couple of tips for deliberation: focus on the key issues. Remember that being a quasi-judicial decision maker is where you have to set your personal preferences aside and make your decision based on the relevant criteria that are already on the books. And you want to do that in terms of discussing the relevant evidence that's presented to you with the criteria in hand. In fact, when you get to deliberations, go back to that page of the staff report, the list of the criteria. I even encourage members who have a screen like this, put the criteria on the screen. And then everybody's focusing on, oh, I'm going to vote in favor because I think it is compatible with the neighborhood, right? Whatever the criteria are, right? I think that they've met the criteria because they're right there in front of you to talk about. So I know sometimes it gets off to a little bit of a rocky start, right? Maybe you had a hearing and the presiding officer brought it back and said, okay, great presentation, thanks everyone. Who'd like to start our deliberations? And I say, Madam Chair, I'll start. And maybe it's, let's say it's a liquor application, we'll start with that. Madam Chair, I'll start our discussion. I'm just going to vote no because I don't drink. We okay there? We're kind of off to a rocky start. Why? Because that's not one of the criteria, right? This is the part of the job. This is one of the jobs we have to set aside our personal preferences. So in that case, there are criteria that apply to liquor licensing, but that ain't one of them, right? It's things like, is the applicant of good moral character? Is the licensed premises at least 500 feet from a school? Get those criteria out and have them at the ready. Oh, what about this scenario? Yes, it's a development application. Maybe it's a final development plan application, and we say, Madam Chair, I'll start the discussion. I'm gonna vote no because I just don't like it. That's a little rough too, but we can fix that just by using what I call Sam's rule of why. Okay, as colleagues, as co-equals participating in this deliberation, we can simply turn to each other and say why. Why don't you like it, right? If my response is Sam in his oafish way says, well, I'm going to vote no because, the applicant didn't contribute to the Christmas gift fund last year, and so I don't like them. No, we're going to throw that one out, right? But if I say, I don't like it because the buildings are too tall, hey, maybe that was the crux issue of the hearing. Maybe the height limit was 40 feet, and this was all about they want a variance to 50 feet, and the criteria that kick in are whether they're entitled to that variance. So when we say, why do you feel the way you feel? And keep drilling down a couple of levels. Why do you feel it's incompatible with the neighborhood? By the way, that's a wholly defensible criteria under Colorado law. Sometimes people are going to stand up and say, I don't know what compatibility means, that's so subjective, and you're just making up your decision. No, that's a legally defensible criteria. But how do we get to explaining that to the people in the room? Use the rule of why. Why is it incompatible? Well, I'm going to vote no, and here's my reason why. I think it's incompatible because they are proposing stucco architecture with all sorts of crazy facade stuff, and our design criteria require pitched roofs, right, and natural siding material. Now you've just made a record of why, and that's going to help you immensely. Yeah.
In most communities,
Yeah.
if that discussion takes place in the planning commission,
Yeah.
is that discussion documented so the council can understand the questions and the reasons behind the decision and the votes?
It depends. It goes back to your question about what's in the record.
I'm asking, how do most do it?
Best practices.
Yeah, most of the time it's primarily the staff report. And the staff report I've seen most commonly over my years of doing it, the staff report to the Planning Commission has an evaluation of the criteria and talks about the various aspects of the application in relation to the criteria. And then that staff report gets updated or supplemented when it goes to the governing body to further explain, right? Sometimes the staff, and it's not universal practice, but sometimes on the crux issues, the staff report will say, the staff report going into the Planning Commission recommended a finding that this criteria was met. But at Planning Commission, here's what happened, and here's an explanation of their view of the event. And that's all getting into the record because it's in the governing body staff report. So you may have a different practice locally. Yeah. Yeah. By the way, that does suggest this little bit heavier lift, right? What if you have the situation where staff recommendation is approval, right? Planning Commission recommendation is approval. And then the Board of Trustees in their analysis of the situation says, well, we've come to different findings and conclusions and we're going to deny. Right? I think there's just a bit of a heavier lift then of making sure the record reflects the reasons for, right, including the differing evaluations of criteria, different analysis that apply, right? And you don't lose a case just because you have documents in the record that had a recommendation that you go one way while you ultimately decided to go the other way. The crux question legally was, is that final decision supportable and defensible? Yes, Margie.
Can I just say too, from a staff perspective and from a clerk's perspective, that it's really helpful to have those approved planning commission meeting minutes in the council packets, because then the planning commission has already decided what goes in them and what doesn't. Does that make sense?
Yes.
I mean, sometimes we would get them and say, they haven't been approved yet. And that would make me crazy.
Yeah, and that takes on a life of its own.
Approved planning commission minutes, and then you know what's being said to council.
Well, and sometimes you have a split decision, you know,
Right.
3-2. And so it went to the council as we recommended approval. But like the Supreme Court, it's nice to see the dissenting opinion too.
Right.
So that the council can understand the way we did.
Right.
What the different viewpoints were.
Right.
And I don't think we do that as well as we can.
Right, and I think, you know, among the municipalities that I've worked with and among our membership, I think that is not a common approach where you have a formal written minority opinion on an issue. But I do think what Margie hit on is a tool that a lot of municipalities use is get either a draft or final minutes in the packet, right? And I have seen staffs where the expectation of the governing body level is make sure the staff report fully reflects what happened to Planning Commission, that the staff report will include, hey, Planning Commission had a split vote on it, their views of this criteria was this. Commissioners A, B, and C looked at it this way, Commissioner Light said that this is the way it should be looked at, and you've got all that to queue up. And it enables you then at the governing body level to have a discussion of that without a due process concern because it's all happening on the record. So, yeah. Yep. I know of, give you just a general sense of how often it occurs. I think I only know of, off the top of my head, 2 or 3 members, and this was a Historic Preservation Commission where they did, and the protocol was specifically to have the recommendation and then a formal document by which those who were in opposition could submit their view to be understood by the governing body. Okay, just 2 more slides for you. One tip is, you know, however that looks like, usually the presiding officer is doing this, but all quasi-judges should have and take the opportunity to speak during deliberations and have a protocol for doing that. It certainly helps build trust in your local procedure. If every single member is called upon and say, do you have any comments, questions, or what are your thoughts on this application? When you're getting ready to act, make sure you have a decision document or a decision motion, whatever that is for your local entity, that properly reflects your decision. Building my earlier comment, if the packet had a recommendation of approval but you want to deny, then you want to take the time to make sure the accurate document is prepared, even if it requires a continuance, right? If you are, we've been talking about bodies here, but if you're a single quasi-judicial decision maker, if you're making the decision on the employment hearing, take the time in the ink, right, to write your decision with your thought process about why I'm going this direction with regard to this matter. So using that as a bridge here, we've talked mostly in our discussion about quasi-judicial bodies in this presentation, but remember that due process requirements apply to a multitude of other decisions, whether it's employment decisions, Your public works director, bless them, they can sometimes be in this realm where they got to have a quasi-judicial hearing to turn off the utility service. If you're an election official, once in a while you've got election rules that might implicate a quasi-judicial due process type of thing. In that regard, whatever process is due is going to vary depending upon the applicable law, the interest at stake. It's really, in terms of pure legal requirements, the appellate decisions are saying, the amount of process and the type of process that's required is not a one-size-fits-all. It's a dynamic balancing of what is the interest at stake, what would be the consequences of depriving that right? And are there applicable laws that apply? But at the end of the day, it's all about providing notice, an opportunity to be heard, and being fair and impartial. And if you embrace those concepts, both the spirit of those concepts and the letter of the rules that apply, you're going to be in a great spot. Ultimately, at the end of the day, sometimes questions bubble up about what are we supposed to do here procedurally. Err on the side of caution. My takeaway from a risk management standpoint is, sometimes it's real tough to know exactly what we should do, but if we err on the side of indulging more process, providing more process, from a risk management perspective, I can tell you that's a better place to be than having a judge later on telling you there was more process that was due, D-U-E, right, than you gave. So, wrapping up my comments, the most important job for quasi-judges is to provide that great product of great process. Be a champion of your process. Know that if you followed your procedures, right, and you carried out your obligations fairly and properly and even-handedly, and if you issue a decision based on the appropriate criteria, then you're going to be in a great place in terms of building trust in local government, in building trust with your body, and your liability risks are going to take care of themselves, and that's an awesome place to be. I apologize. I think you had your hand up for one more question. You're all set? Okay. So with that, I'm done with my presentation. I want to thank you all very, very much for coming out this evening, for helping me with our inaugural run for our training room this evening. I'll open it up to any other questions that you might have. Just a couple of things there. And the last slide, there's some resources for you. There's a link to an electronic copy of the handbook that we handed out. The very first link there is an alternative version of this presentation in a webinar that you can certainly access and share with others that you would like. And then more generally at www.CIRSA.org, the last bullet there is our training resources for elected and appointed officials. So I hope you find those useful. And once again, thank you all very, very much for coming out this evening.